For any practicing doctor, delegation isn't just about efficiency. It's one of the highest stakes areas of medical legal risk you face every single day. A single misstep here can have huge consequences for your patients, your license, and your practice. So the real question is, how do you manage this risk safely and effectively?
You know, the single sentence is the absolute bedrock of delegation law. If you only take one thing away from this explainer, make it this. It's the principle that courts and medical boards will come back to every single time. The task itself can be handed off, but that ultimate accountability, that always stays with you.
So let's get really precise about what this means in a legal context. Because understanding this framework, it's the very first step to protecting yourself and your patients.
Here we have a crucial legal definition. See, delegation is a two-part action. You transfer the performance of a task, but, and this is key, you actively retain the accountability for how it turns out. It's not about passing the buck. It's about extending your reach while you remain the captain of the ship.
And this is where the consequences become very real. These aren't just simple mistakes in the eyes of the law. They are failures in your duty of care. When a preventable error happens because of poor supervision or because you delegated to someone who wasn't qualified, that's negligence. And even something as simple as being unreachable during a critical delegated task can be seen as a failure of supervision.
This brings us to the next vital concept, the legal boundaries that govern every single member of your team. And this isn't some informal system, it's a legally defined framework.
Scope of practice is the rule book. It's determined by a person's formal qualifications, their license or registration, and their documented training. It tells you what they can do, and just as important, what they absolutely cannot do. And let me tell you, relying on someone's experience over their legal scope of practice is a classic medico-legal trap.
Now, it's incredibly important to understand the legal difference between delegating and assigning. An assignment, like asking a nurse to check vitals, is part of their normal job. But delegation, that's when you transfer a task that might typically be yours, like ordering the setup of an IV. The moment you delegate, you automatically trigger your duty to supervise.
This table gives you a really practical overview. The tasks on the left, like collecting samples, those are generally safe to delegate if you have the right protocols. But the core functions on the right, diagnosis, treatment planning, prescribing, these things require medical judgment. They can never be delegated. Crossing this line is a serious legal breach.
Okay, now let's talk about how this plays out in the real world. Because in busy clinics, when you're under pressure, even the best intentions can lead to some really high-risk failures. These are some of the most common scenarios that end up getting people into legal trouble.
The mislabeled sample. It sounds so simple, but the consequences can be absolutely catastrophic. Wrong diagnosis, wrong treatment, everything. If that error happened because the task was given to an unqualified or poorly trained staff member, the liability often traces right back to the delegating doctor in the clinic.
Here's another classic. A technician does a diagnostic test, but they do it incorrectly. Maybe they place the ECG leads in the wrong spots. Now, if you then make a diagnosis based on that flawed data, without checking the quality of the test, you can be held liable for the consequences of that misdiagnosis.
This one is really common. You have a capable assistant who gradually starts taking on more responsibility. Maybe they begin preparing local anesthesia or giving post-op instructions that are actually medical advice. This is what we call scope creep, and it's a huge liability because they're operating outside of their legal qualifications. And this might be one of the most overlooked but dangerous risks, the front desk. A well-meaning receptionist tells a patient their symptoms don't sound urgent, or tries to interpret test results over the phone. Well, they are now practicing medicine without a license. That's illegal, and your clinic is directly on the hook for any harm that comes from it.
So, when something does go wrong, what exactly are courts and legal bodies looking for? Well, they have very clear expectations for what adequate supervision actually means.
Legally speaking, supervision exists on a spectrum. Direct supervision means you're right there, in the room. Indirect means you're on site and can be there immediately. And remote means you're reachable by phone. The crucial thing to remember is this. As you move from direct to remote, your legal risk goes up. The level of supervision always has to match the complexity of the task and the competence of your staff member.
And don't think this is just a localized issue. In India, for example, the courts have a zero-tolerance policy.
They consistently rule that failing to supervise or delegating beyond someone's scope is clear-cut negligence. This principle really reflects a global standard of care.
And here it is, the second great mantra of medical legal defense. From a court's point of view, if you trained a staff member, gave clear instructions, or supervised a procedure, but there is absolutely no written record of it, then legally, it never happened. Your documentation is your proof that you did your due diligence.
Okay, we've laid out all the risks. Now for the most important part. How do you actually build a medical legal shield around your practice? Let's walk through the actionable steps.
This toolkit is your defense. Things like written SOPs, documenting every single training session, and having formal supervision protocols, these are non-negotiables. And tools like checklists and mandating repeat-back communication, they eliminate confusion and prevent errors before they happen. This isn't just bureaucracy, it's your safety net.
So we'll end with this question. It's not about whether your team is good or whether you trust them. It's about whether the system you've built, your protocols, your training, your documentation, is robust enough to defend your decisions and protect your patients when something unexpected happens. Is it strong enough to stand up in court?